My name is Diane Cafferata, and I'm a partner in the Los Angeles office of Quinn, Emanuel, Urquhart & Sullivan, LLP. Thank you for joining us for today's Learn from the Best CLE presentation on some of the unique litigation issues that arise relating to evidence discoverable from related proceedings. This type of evidence may be used to effectively supercharge offensive discovery in a case and often create both big opportunities and serious risks for litigants. Thoroughly understanding the dynamics at play in seeking this type of evidence is important in knowing how to go after it, of course, but it's also critical to effectively defend against overbroad requests for the same evidence. This presentation is designed to get you thinking about how factual information that was first discovered, elicited, created, or submitted in proceedings other than the instant case, what we'll call other proceedings evidence, should be part of your overall discovery strategy. It will include strategies and tips that can be used to leverage this other proceedings evidence to your advantage in any litigation. In this presentation, first, we'll discuss what types of other proceedings evidence is out there, list some sources of other proceedings evidence to consider, and discuss some of the risks and benefits associated with it and why it therefore presents both opportunities and challenges for counsel. Then we'll go over the general legal principles that apply in these situations and show some concrete examples of how one can demonstrate to the court, in one case, the relevance of materials originating in or discoverable from another proceeding. Next, we'll briefly discuss a real-world example from the Qualcomm Apple matters where other proceedings evidence came into play recently, and go into some of the considerations arising from protective orders. We'll then conclude by summarizing some main points on how to develop an effective and safe strategy for the other proceedings evidence in your cases. So what types of information are typically available from other proceedings? Pretty much any facts, as well as positions and arguments that were made in a different proceeding than the instant one and that are in the possession, custody, or control of your adversary in the current matter. Common types of other proceedings evidence, stated from an offensive discovery perspective, include documents that were produced in other matters by one's adversary, documents that were produced by third parties in other matters and that are now in the possession or control of your adversary, interrogatory responses, responses to requests for production, and responses to requests for admission created in other proceedings by your adversary, deposition, hearing, and trial transcripts reflecting the testimony and exhibits from witnesses for your adversary, including those of party witnesses, third parties, and experts. Similarly, any written declarations or affidavits given by witnesses that are affiliated with your adversary, briefing or submissions made to judicial, regulatory, or other governmental authorities by one's adversary, and briefing or submissions made by third parties that are in the possession of your adversary. But these are really just examples. Defensively and offensively, one should think broadly about all the potential proceedings where evidence relevant to the instant proceeding has or could have been elicited. Wherever your client may have made other formal statements or produced materials in the past should be considered a potential opportunity for an opponent or a potential risk for you. Similarly, wherever your adversary may have made other formal statements or produced materials in the past, this can be a potential opportunity for you and a potential risk for them. For example, let's say your adversary brings an antitrust claim against your client. In the course of pursuing that claim, your adversary will potentially be motivated to make a robust production of financial documents related to its relationship with your client in order to prove its damages claims. That same evidence, however, might be extremely useful to proving your damages in your client's subsequent trade secret misappropriation claim against the same opponent, where he will likely fight hard to avoid producing it. Alternatively, your adversary may have produced extensive discovery in the context of a criminal investigation in order to score points with the government for its transparency and willingness to cooperate. But in a collateral civil case, the same entity will likely put up much stronger resistance. You can circumvent its stonewalling by seeking cross-production of the documents that your adversary already handed over to the government. Some of the possible sources for this evidence, therefore, are other litigations or appeals, such as a probate proceeding or a different patent case, PTO or TTAB proceedings, both in prosecution or challenges, ITC proceedings, Court of Federal Claims, criminal or other investigations, bankruptcy examiner productions, international proceedings, and regulatory or compliance submissions. You should be creative. So why is this evidence important to talk about as a category? First, note that other proceedings evidence tends to have a disproportionately strong impact on discovery strategy. Often it can have a disproportionately strong impact on the litigation as a whole as well. And this is because the entity that created or submitted evidence in an earlier proceeding will often have had very different motivations in that original proceeding than it has in the current case. As a result, and also because sometimes the other proceeding is at a later stage than the instant one, at a point where a great deal of discovery has already taken place, requests for this type of evidence can create an additional level of opportunities and risks above that of other, more run-of-the-mill evidence. Other proceedings evidence is also often easier to obtain than other types of evidence because there's relatively little burden associated with producing it again in a separate case. It's already been collected, processed, reviewed, and produced. Evidence from other proceedings can be helpful to fill in document productions and supply substantive evidence. But it can even be more important when used to identify deficiencies in a document production or to impeach your opponent's written discovery responses and/or testimony. A well-planned motion to compel these types of materials can seriously damage an adversary's credibility. In a surprising number of situations recently, I've had an opponent denying the basic content or relevance of evidence from previous proceedings in order to avoid producing it. This has not ended well for the opponent when those representations have proven to be inaccurate. A failure to fully understand or represent what was produced or submitted in that past case can wind up damaging a party's credibility. One should be diligent in exploring this evidence before denying that categories of evidence exist or were previously produced, or before taking positions in the instant matter that directly contradict your client's previous arguments made in the other proceeding. In some cases, evidence available from other proceedings may completely change the dynamic of your case. The Qualcomm versus Apple matters provide an example of this, which we'll discuss more in a few minutes. But as a result of Apple's extremely broad public interest arguments before the ITC, Qualcomm was able to obtain certain discovery regarding Apple's copying and/or misuse of Qualcomm's information. This information became available and a source of leverage in other cases, including a trade secret case between the parties in California Superior Court, where Qualcomm sought billions of dollars in damages before the parties entered a global settlement. As another recent example, in a recent bankruptcy proceeding I was handling in the Southern District of New York for the Lehman Brothers estate, Credit Suisse demanded a full production of everything the estate had produced in two similar matters Lehman had against JP Morgan and Citibank. Prior counsel for the estate had refused to produce these materials on the basis of overbreadth, but when I took the case over, I told them we would make the demanded production, which we did. Having literally produced everything we had, regardless of relevance, and at our adversary's adamant request, for the rest of the proceeding, Credit Suisse was on the defensive about meeting their own discovery obligations. Lehman could not be faulted for non-production, so all of the motions to compel were on the offensive side for us. Now, there are several powerful benefits and opportunities associated with this other proceedings evidence. Starting with opportunities, and again from the offensive discovery perspective. First and foremost, these materials may contain admissions of facts that are directly relevant to the present case or are inconsistent with positions being taken now. Evidence from other proceedings tends to promote truth. What a party says about something before it becomes a controversial issue is typically more honest than after it has become controversial. For this reason, evidence from other proceedings can also facilitate early resolution of the case sometimes. For example, when a corporate party realizes that prior statements and representations that are now available from another case will significantly weaken the positions it is taking in the current case. Second, compelling other proceedings evidence can be a huge shortcut in discovery, obviating the need to pursue other categories of materials or allowing a party to avoid the costs of gathering and producing materials that were previously gathered and produced. Third, producing other proceedings evidence voluntarily in your case may moot an opponent's motion to compel, which might result in putting it on the defensive for not producing more discovery itself. Or it can bury a party in a voluminous production that it cannot be heard to complain about because it demanded it, as occurred in the Lehman matter. Fourth, if an opponent is very resistant to production of evidence from other proceedings, it can help position you for an award of sanctions against that opponent. In a proceeding we had a few years ago against Apple, we won an order sanctioning Apple for refusing to produce relevant deposition transcripts from prior proceedings. This sanction was critical to neutralize an adverse inference instruction that was being taken against our client for unrelated reasons. There are also risks and challenges associated with the production of evidence from other proceedings. Of course, it is a problem if you are the party who made representations that are inconsistent with the current positions being taken by that party. You might want to oppose your opponent's effort to obtain this evidence, but it would generally be better to have anticipated or avoided this problem by not making such inconsistent statements. Second, because the production of this evidence may be a big shortcut in discovery, it may create a tactical disadvantage for a party to produce or receive a great deal of discovery material early on in the litigation. Third, a request for evidence from other proceedings often increases the overall burden of discovery. Although it might be a shortcut in some ways, very often the overall scope of discovery would be somewhat narrower without the earlier proceeding having taken place. A potential disadvantage for both parties is that increasing the scope of discovery significantly may increase quantity and burden of review without a commensurate increase in the quality of the production. Fourth, there can be a further increase in the overall scope of the case, because the production of these materials might lead to additional depositions or additional third-party discovery. Also, the fact that there is little burden to producing this evidence from other proceedings means that more of a fishing expedition might be permitted than it would be otherwise. Also, seeking or avoiding the cross-production of evidence can implicate protective orders or confidentiality obligations to third parties, which can make this discovery complicated and/or pricey to deal with. Finally, as usual, one needs to be careful what one asks for. A party making an overbroad demand for reproduction of productions from other cases may find itself suddenly explaining why it hasn't produced more discovery itself. Evidence from other proceedings comes into play in all kinds of cases. Here are just a handful of types of cases where I've personally seen these issues come up in the last several years. Trade secret cases, patent cases, fraud cases, such as those relating to residential mortgage-backed securities, and contract disputes between financial institutions. But they really can come up in any case where an entity has been involved in prior proceedings. The main element that drives the production of evidence from other proceedings is relevance. Whether state or federal, courts have focused on whether the production of this evidence from another proceeding actually has a bearing on their case. Here are some quick examples that highlight the reasoning and tests used by courts to determine whether the evidence from the other proceeding is relevant enough and should be produced. In Alloc, the court found that the two cases were linked because they had the same accused products in them. In Waters, here too, the two cases were found to have similar facts and claims. In Inventio AG, the inventor's testimony and documents from a patent litigation were found relevant to another matter. In U.S. Bank, the court found the transcripts related to the defendant's knowledge, which was an issue in the present case. In Home Equity Mortgage Trust, the court looked at the volume and nature of the underlying evidence as reflecting a pattern of problems. And in Apple versus Samsung, which was one of my patent cases where we represented Samsung, transcripts from Apple employees and documents from Apple were ordered to be produced from cases that had a technological nexus with the instant case. Now, how do you convince a court that discovery you haven't seen in a case that is not before the court is relevant in the current action? Step 1 in developing a strategy to go after this evidence calls for identifying overlapping discovery between similar cases involving the adversary. This is easiest when the parties are the same on both sides, like the Qualcomm versus Apple cases, but that's not necessary. To identify potential relevance overlaps, start by comparing the complaints and answers from your case and the collateral case or cases where the evidence that you seek was produced. Other public statements may be used for this as well. Also, sometimes you won't know all of the cases that might be out there, in which case you can try to put the onus on the adversary to identify those cases. We were able to do this in the Samsung versus Apple case, where the court ordered production from cases with a technological nexus to ours, because we were unsure that we had a full identification of such cases from Apple. Once you've made this comparison and know what to ask for, you have to find a way to help the court understand the connection between the discovery you need from the prior case and what's at issue in the present case. I've included here a few real-life examples that we've used to effectively demonstrate this. First, here's a chart I used in a mortgage-backed securities case against Bank of America. Nothing in any of these slides is confidential. Basically, there was a Department of Justice complaint against our opponent, and then we separately had a civil case, and the two proceedings had very similar underlying allegations. So based on a comparison of these allegations, we were able to show that materials produced in the DOJ investigation were responsive to our requests for production in the civil case. Similarly, in a design patent case against Apple, we used this demonstrative to show how materials related to one design patent were likely relevant to cases involving other design patents, simply because the designs clearly had many elements in common. In these slides, I'm showing another chart that we used in briefing in one of the Samsung versus Apple cases to demonstrate why materials relevant to patents at issue in the ITC and materials relevant to patents at issue in a civil patent case should be cross-used. We showed that most of the disclosures in the respective patents at issue were exactly the same. The inventor, the third-party prior artist, and engineer testimony from one case was obviously relevant in the other case. Looking back at the legal principles that are involved here, you should note that general practices, not just specific products or transactions, are likely relevant. Here are a few cases in which other proceedings evidence was useful to illuminate the overall practices and procedures that were employed by a litigant over time. Also, documents that post-date the transactions that are at issue in your case can still be relevant because they can show how things were likely done around the operative time period. On the other hand, if a request is really sweeping and overbroad and would encompass a high volume of irrelevant materials, this can be persuasive in getting such a request denied. Here are some examples. In New Jersey Carpenters Health Fund, the court drew a distinction loud and clear and said that the plaintiffs were free to seek specific information, but saying something like, "You gave documents to the government in an investigation," just wasn't good enough. In the Woolem case, the request to clone discovery was deemed too far away from the claims and defenses in the other case. In Moore, again, the sheer fact that materials had been produced in another case without a showing of how that information actually tied to the claims in this case didn't cut it. In American Eagle Outfitters, the party seeking evidence from another proceeding did not draw a sufficient connection between the instant case and the past IP cases. And in Austin versus Nestle, the deponents were appearing in both cases, so the discovery from a similar case was limited to testimony and statements from those deponents who were also appearing in the Austin case. Now, as in other discovery motions, any relevance must be balanced against the burden of the reproduction. If the other proceedings are relatively recent and information was produced electronically, it may be difficult to argue that there will be a significant burden in producing it in the instant case. If your client's opponent in this proceeding was also your client's opponent in the other proceeding, then those other productions to each other may simply be deemed produced or cross-used in the latter proceeding by agreement between the parties. One can often do this with a simple letter of confirmation. When seeking other proceedings evidence from others, I often will serve a request for the entire production, as well as separate requests for subsets of relevant materials that I know are within that production. This makes it difficult for an adversary to oppose production of the relevant subsets on the basis that they are too burdensome for it to produce. I can point out that the opposition could always comply with the other broader request instead, especially when a protective order is already in place, and simply flip the entire production to me. Courts tend to be sympathetic to reasonable requests for this kind of material. Federal courts have acknowledged that such reproductions further the goals of the federal rules by eliminating costly rediscovery. Now I'll turn to a recent example where these issues came into play. The Qualcomm versus Apple litigation, in which we represented Qualcomm, involved over 10 cases across 3 continents. Commentators describe this global litigation effort as one of the longest-running and most expensive disputes in the tech industry. Each of the battles in the broader war between the two entities carried different stakes and involved different issues. For example, in the ITC investigation number 337TA-1065, Qualcomm sought a ban on imports of iPhones, which is the only relief a party can seek at the ITC. In the district court companion case to that action, Qualcomm sought less than $30 million in damages based on infringement of the same patents. At the same time, though, Qualcomm brought a breach of contract and trade secret misappropriation claim against Apple in San Diego Superior Court. In that case, the monetary stakes were significantly higher, with Qualcomm seeking billions of dollars in damages. So on behalf of Qualcomm, we compelled some materials from Apple relating to alleged copying and misuse by Apple of Qualcomm's proprietary information in connection with the broad equitable defenses that Apple had asserted in the International Trade Commission investigation. Although Apple eventually withdrew these defenses, in the meantime, Apple had significantly expanded the scope of discovery by asserting them, and it wound up compelled to produce substantial discovery related to this alleged copying and/or misuse of Qualcomm's information that might not have otherwise been required. In this slide, you can see excerpts from the court's public order in the ITC giving Qualcomm unfettered discretion to explore Apple's alleged copying and misuse of Qualcomm's information and ordered Apple to produce the related materials. Then, in the trade secret proceeding in San Diego Superior Court, we sought access to these same materials from Apple. Now, Qualcomm's discovery requests seeking cross-production of those documents in the trade secret case had not yet proceeded to a motion to compel before the parties were able to achieve a global settlement. However, public statements from ALJ Pender in the ITC case regarding the relevance of the discovery sought would have made it extremely difficult for Apple to credibly argue that the discovery sought was not relevant to Qualcomm's trade secret claims. Now, you'll note that the moment that it was granted, Apple's counsel recognized that this order opened the door to potential use of this alleged copying evidence in other later cases. He tried to use the protective order to designate the transcript itself as confidential, which would have concealed the ruling and created an obstacle to compelling that information later in another case. Thankfully, this request was denied. Now, speaking of this, we should take a few minutes to discuss how protective orders play into this, because it's a hugely important issue. Let's consider a scenario where you're aware of the other proceedings from which you are seeking cross-production. Let's say you were counsel in the collateral proceeding. You may have knowledge of or may have actual access already to materials from that proceeding. But you cannot assume, if you have that access, that you can start using those materials in your case, even for the limited purpose of arguing for their production in your case. You may have one or more protective orders that prevents you from doing so. You must be very sure you're not violating the terms of the protective order or orders that are in place in the underlying cases, and this is not always easy to do. First, don't get confused if your adversary seeks to avoid production by saying there's a protective order in place in the original matter. A protective order can make obtaining evidence from other proceedings more complicated, but it does not shield documents from discovery at all. A party cannot protect its own production from disclosure by designating it. However, a protective order can be an impediment toward an effective effort to get cross-use because it may limit the ways in which you can safely argue for the reproduction of those materials. You must be careful not to make your argument about what material from one case is relevant in the instant case based on confidential information in that first case. A protective order might require parties to use or utilize designated confidential business information solely for the purposes of that litigation. Use or utilize A could be narrowly construed to mean disclosure, or B, it might be broadly interpreted to prohibit any reliance on protected materials for any reason. I've actually seen a spectrum of arguments in this regard. If there's a narrow interpretation of that term, then using the same counsel on groups of cases who are legitimately reviewing the information in each case for each of those cases will be an advantage because counsel will just know what types of information might be relevant to more than one matter and can use that generalized knowledge to seek its cross-production. However, under a broader interpretation, more creativity may be required. For example, you may need to identify public statements from your adversary describing the contents of their production, which you can then quote in your discovery motion briefs. You can turn your adversary's statements touting the depth and breadth of their production against them. Often, you might not be sure how use or utilize will be interpreted, and so relying solely on materials from the public record, and in particular characterizations from the opponent in those other cases about what they were producing, may be the best way to go. The last thing you need is some sideshow over a supposed protective order violation to distract the court from your strong motion to compel. Even so, sometimes your adversary is worried enough about the production of this evidence in the new matter that he threatens to report you for protective order violations, even though you were very careful. Hopefully you have been careful to avoid actually violating any protective orders. You must be sure that you actually know the scope and meaning of the particular protective orders at issue. Do not rest on assumptions about what constitutes use or otherwise qualifies as a protective order violation, as the actual protective order at issue may be broader than you think. For example, ITC protective orders prohibit any reference to confidential documents or information produced in an ITC proceeding, even at a high level. So it's best to err on the side of caution. And then, if necessary, in any briefing or argument, remind your judge that protective orders are really designed to protect sensitive information from open disclosure. They're not intended to allow a party to tell one story in case A and then a completely different story in case B. And they're not intended to prevent you from identifying the deficiencies in your opponent's production. Underscore your opponent's use of the protective order as an anti-truth rather than anti-disclosure measure. Also, be cognizant of the position your adversary has taken as to the scope, breadth, and meaning of the underlying protective orders, and whether your adversary has acted consistently with that understanding. Often I've found those screaming the most about a supposed breach of protective order are actually the ones violating it. Quite often, especially when there are multiple proceedings between the same parties, there are a variety of ways to seek cross-production. But usually you start by serving requests, as I mentioned earlier, and then simply ask your adversary to agree to cross-production of the responsive materials from the other proceedings. If your opponent agrees, then you can often obtain the discovery that you need by simply filing a stipulation memorializing this agreement with the court, or sometimes even with a letter agreement. If your adversary will not agree to enter into a cross-use agreement, you should propound discovery requests seeking cross-production of the information you seek. your adversary's unreasonable refusal to agree to a cross-use agreement will often provide useful quotes and citations for the eventual motion to compel regarding these claims. Be sure to look out for, and these are just examples, blanket assertions that the cases address separate issues, which will undermine your adversary's credibility if you can show that there is actually substantial overlap between the two cases, vague allusions to the volume of documents produced in the collateral case designed to play up the burden associated with cross-production, which you can then undercut by explaining that you're amenable to deeming documents produced in your case, and references by opposing counsel to documents such as expert reports that include your confidential information covered by a protective order. Opposing counsel might not be legitimately able to access these because they have not signed the protective order in the collateral proceeding. This may allow you to spot a protective order violation on their part. So here you can see depicted some of the cross-use agreements that existed between Qualcomm and Apple at a very high level. Many of these agreements were limited in scope to certain types or collections of materials, but this gives you an idea of how prevalent this issue can be between busy litigants. To conclude, I've assembled a few basic takeaways to keep in mind in your future cases. First, once produced, always produced. Like emails, produced documents, deposition transcripts, and arguments made in court may not be limited to just that case. They could be brought into play in other cases instantly. Second, consider the effect of positions taken and/or discovery produced in a particular case on your discovery strategy in other cases. Know where the adversary has been making statements. Watch the dockets. Third, you might consider other proceedings evidence when choosing lead counsel or assembling case teams. Using the same counsel and ideally the same attorneys on multiple cases is the easiest way to coordinate your efforts, but it can also be accomplished via close collaboration between counsel staffed on multiple matters. Bottom line, it's much easier to know what happened in a prior case when you actually worked on that prior case. But whatever the arrangement, you need to make sure to have a thorough understanding of what discovery has been produced in the collateral matter, how this evidence from other proceedings relates to the instant dispute, and what documents have been cross-produced between cases, all the while being careful to honor the terms of any applicable protective orders. Finally, stipulate that any other proceedings evidence you seek will be deemed produced in order to undercut arguments that cross-producing documents would be unduly burdensome. By simply agreeing that the discovery sought may be used in the instant case without reproducing or relabeling the documents, you avoid the cost and time lost to doing these things. This also makes it easy in some cases to agree with your adversary's initial demand for extremely broad cross-use from another case. So that's our presentation for today. We hope you enjoyed it. For more information, please feel free to email me at dianecafferata@quinnemanuel.com or call our Los Angeles office at 213-443-3000. You can also learn more about our firm on our website.